I hope my screen is visible. I hope I am visible. I hope I'm audible. Please, one of you just put it out on the chat box. All right, cool. Thank you. So, as you can see with the title, today's session I will be conducting as well as your task would be on arbitration agreement. Now, first of all, a basic introduction about an arbitration agreement. The dictionary meaning of arbitration is the process of solving an argument between two people and helping them to agree on an acceptable situation. Now, arbitration is part of the ADR mechanism and it benefits parties who want to avoid normal lengthy recourse to the local courts for settlements of disputes. Now, it is a legal technique for the resolution of dispute outside the court, where the parties to a dispute refer it to one or more person, namely arbitrators, whose decision, what it is called the award, that they agree to be bound to. Now, advancement, liberalization, globalization of international businesses, etc., um, necessitated the invention of a more uh, accused friendly or a more party friendly approach, which is flexible, reasonable, helps in resolving disputes quicker, time saving, money saving, cost effective um, method of resolution of disputes without going to the court and going through the rigorous legal procedure. Even though the traditional justice delivery system is something that um, it is, as we all know, a very lengthy procedure. There are many backlogs of cases. So to prevent more cases being dumped on our courts, we as in humans came up with something known as the alternative dispute resolution. Now, alternative dispute resolution consists of about mainly four kinds of dispute resolution mechanism. One is the arbitration, one is the mediation, one is the negotiation, and one is the conciliation. Now, there are four kinds of ADR mechanisms, and arbitration is the one which is which is mostly the most court-like procedure because there is an arbitrator and he acts like the judge again. Please keep that in mind. He only acts as the judge. He is an arbitrator and his decision is binding on the parties who are part of the dispute. His decision is known as the award, whereas the judge's decision is known as the judgment. Now, a judgment can be appealed, same way an award can also be appealed, but usually it's again like get going back to the traditional Indian legal system, which usually people don't want. They just have the arbitrator review the award, and they have the arbitrator recheck the award or re-go through the whole procedure over again, or they appoint a different arbitrator and they have the proceedings over again. Now, the Indian law with respect to the arbitration is largely based on English common law. Now, the Indian arbitration is governed and regulated by the Arbitration and Conciliation Act of 1996, which derives its basis from the ancestral model law on international commercial arbitration and the ancestral arbitration rules of 1976. Now, these are the two international norms which govern, on the basis of which the Arbitration and Conciliation Act was basically enacted. Now, ancestral model rules, a lot of those provisions are just copy pasted from the ancestral to the Arbitration and Conciliation Act. Now, usually arbitration is more often than not done to resolve two big business corporations or conglomerates coming together, and usually it ends up with um, one of them having a problem with the other, in which they agree to resolve outside of the court. Now, usually they prefer arbitration because they want to have a third neutral party. Now, now, in the recent years, arbitration has become a very um, growing it's a topic of discussion, and it is everywhere. Like everyone wants to get into arbitration. Everybody wants to do something on arbitration, and it has grown in leaps and bounds worldwide. and that is mainly due to the principles of party autonomy and confidentiality. Now it has flourished as a standalone dispute resolution mechanism. Now again, ADR mechanisms are always have always been there. They've always existed. They have coexisted with the traditional legal system, but the arbitration is something like, let me give you an example. Now, if you have two companies coming together, they've agreed to a contract. Usually, contractual disputes are resolved through arbitration, or you have the um, conciliation. Now, conciliation or mediation also sometimes, but usually people prefer, or companies prefer arbitration because it is more, it has something that they can follow, and it has like a proper set of rules that they need to be following. Now, those rules are again mentioned in the Arbitration and Conciliation Act. Now, Arbitration and Conciliation Act is the bedrock, or it is on the basis of which arbitration is conducted. Conciliation again is not, I mean, it doesn't have as rigorous procedures, I mean, rigorous steps to be followed as the arbitration. But again, anything related to conciliation is in the Arbitration and Conciliation Act of 1996. Um, Again, a new act has been tabled in the parliament. Uh, it is known as the Mediation Act. Now, since mediation is also a very growing topic, we need a law to govern it because it's being going haywire. So the Indian Parliament decided on enacting, or at least introducing the act to the houses, which is known as the Mediation Act. I'm not sure if it passed or not, but I do have a copy. If you all need it, you can obviously message me and I will send you that copy. Again, Arbitration and Conciliation Act is also very small act. It's not very lengthy like the IPC and the CRPC and CPC, but it is a really good read, the Arbitration and Conciliation Act as well as the Mediation Act. It's a very good read. Please, I request you to go through it. Moving on to the kinds of arbitration. Now, there are two kinds of arbitration. We have the ad hoc arbitration and the institutional arbitration. Now, the conduct of arbitration by the tribunal following the rules already agreed between the parties, or following the rules laid down by tribunal in case of non-existence of agreement with the parties. Now, ad hoc arbitration is where an institution is not involved. You've just agreed on arbitrators, and the arbitrators mutually with the consent of both the parties decide on the procedure and decide on the rules, and more any number of arbitrators, more than one arbitrator, is known as an arbitral tribunal. Now, and usually arbitrators are mostly, more often than not, in odd numbers, so that in case there's a split in decision, there's always, a third person who will, be the tiebreaker of basically. But if there is only single arbitrator, again, I usually arbitrators are appointed with the consent of both the parties. So ad hoc arbitration is where an institution is not involved, but institutional arbitration, as the name suggests, an institution is involved. Now, ad hoc arbitration helps in greater control over the arbitration process, flexibility to decide the procedure, and also ensures cost effectiveness. However, an ad hoc arbitration can succeed only if there is agreement and consensual agreement between both the parties. Now, institutional arbitration, on the other hand, the administration of arbitration is in accordance with the rules and procedure of an institution. Now, the same provides for important aspects of arbitration, such as appointment of arbitrators, managing arbitration process, identifying venues for holding arbitration hearings. So, all of those are basically mentioned in the institution rules. For example, you have the ICADR rules. Um, ICADR is basically an institution which helps, doesn't help. It is an institution where arbitration proceedings are conducted. The institution gives you everything. They give you a venue, they give you arbitrators, they give you the procedure that needs to be followed. They even give you an award at the end of the whole session. Now, an arbitration is not a one-time session. It sometimes goes on for years together. Um, many such Indian arbitrations are administered by the international arbitral institutions. Now, more than there being so there are only 35 arbitral institutions, as you can see in the PPT. Now, those are for domestic, international, PSUs, trade and merchant associations, and their city-specific chambers of commerce and industry. Now, these are the kinds of arbitral institutions that are there in India. But outside India, you have the Court of Arbitration of International Chamber of Commerce, the Singapore International Arbitration Center, you have the London Court of International Arbitration. Now, these are the three main institutions which are super popular amongst all the countries, and they more often than not refer their arbitration disputes to these particular institutions. Now, in India, specifically, if you want to come to Bangalore or Karnataka, because that's what I know of, you have the I'm not sure if you have any international arbitration institutions, but I'm sure there are some. All of you all could do a research on that as well if you have time. And if you want to submit your research to me, again, all welcome anytime. Um, Now, one second, guys. Okay. Now, now all of these institutions, all of the arbitral institutions, either have their own rules or are governed by the ancestral model laws. Institutional arbitrations, because they are mostly international law based, what happens is that if you focus on one particular country's law, the other country who has been functioning on the basis of their law, something that might be legal in India might not be legal outside. Something that's legal outside might not be legal in India. A classic example, marijuana. It's illegal in India, apart from it being used for medicinal purposes, but it's legal in some other states outside of India because, again, it's a huge revenue to the government, um, and and to the people who produce and sell those kind of products, basically. Now, the institutional arbitration helps in getting a clear set of arbitration rules, a clear timeline to conduct arbitration, a panel of arbitrators to choose from, as well as assistance from highly trained staff when the parties lack proper knowledge regarding arbitral proceedings. Now, institutional arbitration seems like it is a more, you know, would be more preferred form of arbitration, but there are certain drawbacks as well that it's a little more costly than ad hoc arbitration. It is more constrained than the ad hoc arbitration. It is more like okay, within five like in institutional arbitration, they have a certain timeline by which they need to do everything. Now, in an ad hoc arbitration, again, those timelines are decided between the parties with the arbitrator or the arbitral tribunal present. So it's more party friendly that way. But institutional arbitration is more party friendly in the way that disputes are resolved quickly because you have an institution involved and there are penalties if certain um, procedures are not followed according to the particular institution rules. Now, moving on, we have the arbitrability of dispute. Now, Shivani, please mute yourself. I have done it now. Please try not unmuting yourself. From this point on, we will be doing case intensive studies, right? Anything I will be talking about will be backed up by cases by the Supreme Court or by certain arbitral institutions. And we will also be focusing on the Arbitration and Conciliation Act. Now, this is a very, very important topic, arbitrability of disputes. Now, it is pertinent to know whether the subject matter of a dispute is arbitrable or not, because according to Section 34, Clause 2, Clause B, an arbitration award can be set aside by the court if the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being enforced. And since neither of the acts explicitly exclude any category of disputes as being non-arbitrable, the question again is settled by the courts in these two cases. Now, Section 34 is basically setting aside of an arbitral award. Now, setting aside of an arbitral award, under that there is clause 2B, clause 2, subclause B, which says that the subject matter of the dispute, any subject matter which is not arbitrable, can be set aside by the court. Like I already mentioned, arbitral award can be appealed, and it can be appealed only to the High Court and nothing below that. Now, again, it again depends on the law for the time being enforced. And since no act, honestly, in which is in practice right now, specifies what kind of disputes are arbitrable and what kinds of disputes are not arbitrable. So the question is basically on the courts to decide, what is what. Now, before the Arbitration and Conciliation Act of 1996, the question of arbitrability of dispute was referred to the court and the decision of the court was deemed final. Now, in Uttam Singh Duggal and Company versus Union of India, the contractor was required to pay compensation for the loss caused by delay of performance of contract. Um, Again, it was in accordance with the provisions of the contract. The contractor basically filed a suit challenging the validity of the levied, the levied costs, and the court refused to stay and held that the matter was not arbitrable. Now, since this is a contractual dispute and contractual, again, the court in that particular case basically held that the such cases are not arbitrable. But um, after the enactment of the 19, so before 1996 Act, we had the Arbitration Act of 1970. Now, guys, please mute yourselves. So, during the 1970 Act being in force, we had a case of Uttam Singh Duggal and Company versus the Union of India, wherein a contractor basically um, applied, yeah, he filed a suit basically challenging the levy of penalties on him because he did not complete the contract on time, or he did not, or the contractual terms was not fulfilled by him. But the court decided that such a dispute was not arbitrable and that they had to go via the court procedures only. So that was held in the Uttam Singh Duggal and Company versus Union of India case. Now, after the enactment of the 1996 Act, the arbitral tribunal was empowered to decide upon its jurisdiction and the arbitrability of disputes referred to it. Now, the 1996 Act basically gave more power to the arbitral tribunal to decide whether a particular act or a particular kind of subject matter was a dispute which could be referred to arbitration or not. Because initially the arbitral tribunal didn't really have that kind of power. It was only up to the courts to decide whether a particular case was arbitrable or not. Um, After the enactment of the 1996 Act, that again, like I already mentioned, the tribunal was empowered to decide upon its jurisdiction and the arbitrability of disputes referred to it. Now, this change brought down a number of cases being referred to the court. However, many questions about the arbitrability of several disputes remained unanswered. Now, moving on, we had the Booz Allen case. Now, uh, the Booz Allen and Hamilton versus SBI Finance is uh, is a landmark judgment on the arbitrability of disputes, and it has a lot of it is basically the grunt norm, which is any kind of dispute. If you want to see if it is arbitrable or not, you refer to the Booz Allen case. Now, the Supreme Court basically stated that every civil or commercial dispute, contractual or non-contractual, which can be decided by a court, is in principle capable of being adjudicated and resolved by arbitration unless the jurisdiction of arbitral tribunal is excluded either expressly or necessary or by necessary implication. However, the court also recognized that certain disputes shall be excluded from being adjudicated in private fora and be reserved for their respective fora. Now, the court basically stated that any matter, civil or commercial, which includes contractual and non-contractual disputes, can be decided or can be adjudicated by an arbitral tribunal, basically. But again, the court also specified that there are certain categories or certain kinds of um, disputes which cannot be kept private and it cannot be kept confidential. It needs to be known to the wide public or it needs to be known to the public as a whole. So the court went on to list out such matters, and those are there are disputes relating to rights and liabilities which give rise to or arise out of criminal offenses. So any criminal offenses is not arbitrable. Any rights and liabilities which will lead to there being a criminal procedure or which has arise out of a criminal offense is again not arbitrable. Then you have matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights, child custody, etc. is not arbitrable. It can be done. It can be resolved through mediation, or but again, mediation is also it also needs to be followed by a court hearing where the decision is finalized and not finalized. Then you have guardianship matters. Guardianship matters is not arbitrable. Um, Insolvency and winding up matters, it's again not an arbitration matter. It's usually the commercial courts matter. Then you have testamentary matters, grant of probate, letters of administration, succession certificates, etc. Not arbitrable. Eviction or tenancy matters governed by special statutes where the tenant enjoys statutory protection against eviction and only the specified courts are conferred jurisdiction to grant eviction and decide the disputes. Now, these are the kinds of matters which are not arbitrable. Now, the Booz Allen case also provided a test for deciding the arbitrability of disputes. Now, the court stated, this is what the court stated. The scope of arbitrable disputes must be limited to those concerning rights in personam or personal rights enforceable against certain individuals. Right in rem, which is rights exercisable against the world at large, are excluded from the scope of arbitrable disputes. Now, people who have done your who are done with your first semester know that there is something known as right in rem and rights in personam. Rights in rem are those rights which are yours against the world, and right in personam are those rights which are against certain individuals or certain conglomerates or certain companies for that matter. Now, in under the Companies Act, all companies are artificial persons or legal persons. So, your personal rights against the company are also arbitrable disputes. Company and company against each other are also arbitrable disputes. But if there are rights which you can get, which are against the entire world or against everyone, that is not right in them is basically not arbitrable. Now, okay. So, in case the arbitration agreement enumerates and limits the kinds of disputes arising out of agreement, it shall be noted that even if a dispute is capable of being decided by arbitration and falling within the scope of arbitration agreement, it will not be arbitrable if it is not enumerated in the joint list of disputes referred to arbitration. Although the tribunal is capable of deciding the arbitrability of dispute, it is limited by arbitration agreement, and the arbitral tribunal therefore cannot venture outside the scope of arbitration agreement. Now, coming to the main point or coming to the main, your topic for discussion, I could not have, um, guys, please, guys, stop touching your phone. Okay, moving on. Arbitration agreement is the kind of is an agreement entered into between two parties wherein they agree to get certain disputes resolved through arbitration. And these cases again are all the disputes which can be referred to arbitration are mentioned in the arbitration agreement. Now, although the arbitral tribunal can decide on the if whether a dispute is arbitrable or not, it is again bound by the arbitration agreement. If the arbitration agreement does not state a particular dispute can be referred to arbitration, the arbitral tribunal cannot take it up unless again it's agreed by both the parties that okay, this dispute is arbitrable. If one party says that it is arbitrable and the other says that it's not arbitrable, what basically happens is that there will be a clash between two parties. So the arbitral tribunal usually does not venture into any disputes that is not mentioned and agreed to in the arbitration agreement. Now, one second. Okay. So basically, the Booz Allen case and the Uttam Singh Duggal case before the Booz Allen case act as the crux for getting an arbitration agreement into play. Okay, guys, there is just 30 seconds left. I will just be starting another meeting once the video is converted. Please join that time. Thank you.